Tony DeWitt here, Missouri appellate attorney, retired. None of what follows is legal advice. I'm here to do some video for you today to talk about an interesting subject on the law, and here it is. Today we have another one of those cases that flies underneath the radar, I think, for the news media nationally, and I think provides an interesting glimpse into how courts decide controversial cases. This is Beth Bowen versus Energizer Holdings et al. It was decided by the United States Court of Appeals for the Ninth Circuit, and it deals with sunscreen. This case was decided in October of 2024, and the case centers on claims related to benzene contamination in Banana Boat sunscreen products. Now, I don't know if any of you have ever used Banana Boat sunscreen products or not, but if you have, maybe you want to pay attention here. This case is from the Central District of California. There are 3 districts in California. There's the Northern District, the Central District, and the Southern District. This is from the Central District, and the plaintiff, Beth Bowen, filed a class action lawsuit against several defendants, including Energizer Holdings and Edgewell Personal Care, alleging that their Banana Boat sunscreen products contained an unsafe level of benzene, which is a known carcinogen. When you think about benzene, it's one of the chemicals that's usually in gasoline. The district court in this case had dismissed Bowen's case because they said she lacked standing under Article 3 of the U.S. Constitution because she had not demonstrated any actual or economic harm. Bowen appealed this dismissal, and the Ninth Circuit Court of Appeals reversed and remanded the case for further proceedings. So let's take a close look at the facts here. Beth Bowen is a Californian who purchased several bottles of Banana Boat sunscreen between 2017 and 2020. The products she purchased were Banana Boat Ultra Sport sunscreens with different SPF levels. And of course, SPF is a sun protection factor level. Bowen had some of her sunscreen tested in a lab and found that it contained 0.29 parts per million of benzene. She also referenced tests from a third-party pharmacy, Valisure, which found benzene in other Banana Boat products. Bowen alleged that the presence of benzene made the products unsafe, contrary to the labeling that stated the sunscreens were safe for use. Bowen filed the lawsuit claiming that the defendants violated California consumer protection statutes by failing to disclose the presence of benzene and by misleading consumers through false advertising. There are 2 primary legal issues in the case. The first is Article 3 standing, whether Bowen had standing to bring her lawsuit in federal court, specifically whether she suffered an injury in fact, which is required for Article 3 standing under the Constitution. The second issue was misrepresentation and economic injury, whether the defendants, through their alleged misrepresentation of the safety of the sunscreen products, caused Bowen to suffer an economic injury by paying for a product that was not as represented, meaning that it was not safe. It contained benzene, that wasn't disclosed, and under California's labeling requirements, it was required to be disclosed. So Bowen advanced several arguments in favor of her having standing. First, she said that she suffered an economic injury because she paid for a sunscreen product that was contaminated with benzene, which she would not have bought or would have paid less for had she known about the contamination. Now, obviously, what she's saying is she wouldn't have bought it at all because clearly she's worried about the health effects of benzene. And speaking of health effects, she also alleged that benzene is a dangerous carcinogen and cited a Yale dermatologist who stated there is no safe level of benzene in sunscreen. And then she also claimed the defendants falsely advertised the safety of their products by failing to disclose the presence of benzene, violating California's false advertising law. But of course, the defendants had some arguments to counter that. They said, look, she wasn't injured. They contended that Bowen had not suffered any actual harm because the levels of benzene found in the products were within the 2 parts per million limit set by the U.S. Food and Drug Administration. The defendants relied heavily on the FDA guidelines, which allow up to 2 parts per million of benzene in products like sunscreen, asserting that their products complied with these standards and were therefore safe. They also said, look, Bowen's claims about potential health risks, they're speculative, as benzene levels in tested products were far below the threshold that could pose a real health risk. So the Ninth Circuit reviewed the district court's dismissal de novo, meaning that the appellate court considered the issue of standing from scratch without deferring to the district court's conclusions. The case involved a factual challenge to Bowen's standing. In a factual challenge, the court considers evidence beyond the complaint to determine whether the plaintiff truly has standing. But as we'll see, the Ninth Circuit found that the district court went way too far in resolving factual disputes at this early stage. The core legal rule in this case is what Article 3 requires for standing, and it requires, 1, an injury in fact. And the courts always say that that's a concrete, particularized, and actual or imminent injury. And then it requires causation, a direct connection between the injury and the defendant's conduct. And then 3, redressability, a likelihood that a favorable court decision would remedy the injury. In consumer protection cases, overpayment for a product due to misrepresentation can satisfy the injury in fact requirement even if there is no physical harm. In fact, in most states, there doesn't need to be a physical harm so long as there is an economic injury. It's not every state, but most states. One of the northeastern states in its consumer protection statute requires that the defendant's conduct reach a, and I'm not making this up, level of rascality, which I've always thought to be such a great phrase. The Ninth Circuit analysis focused on 2 main errors by the district court. First of all was intermixing standing along with a discussion of the merits of the case. The court explained that when standing is intertwined with the merits of the plaintiff's claim, here the alleged economic injury due to false advertising, the district court should not resolve factual disputes at the motion to dismiss stage. It should instead treat the issue like a motion for summary judgment, leaving disputed facts for trial. In other words, when the defendant said, hey, it meets the safe level of benzene for these products, the court should not have accepted that as a resolution to the disputed facts where the plaintiff says, no, there is no safe level. The appellate court held that the district court prematurely dismissed the case by weighing this conflicting evidence on the safety of benzene. And the Ninth Circuit also found that Bowen's allegations of economic injury were sufficient to establish standing. She claimed she paid for a sunscreen product that she believed was safe based on the defendant's representations. But she would not have purchased that product had she known that it was contaminated with benzene. According to Ninth Circuit precedent, this kind of overpayment claim satisfies Article 3 standing. Ultimately, the Ninth Circuit reversed the district court's dismissal and ruled that Bowen had adequately established Article 3 standing. The court remanded the case for further proceedings, meaning the lawsuit would continue in the district court where the factual disputes about benzene safety and the accuracy of the defendant's advertising could be addressed. The case has some important implications. First of all, it's a win for consumer protection. The decision reinforces the rights of consumers to challenge misleading advertisement and seek redress for overpayment, even if the alleged harm involves relatively small amounts of potentially harmful substances like benzene. Product safety standards. The case highlights the complexities of product safety regulations. Even when a product complies with FDA guidelines, consumers can still challenge whether a product is safe based on additional evidence, because once the FDA decides that a certain level of a chemical is safe, that does not foreclose someone else from coming back with later acquired evidence and challenging that decision. And then it also gives some credence to the idea that businesses need to ensure that their product labeling and advertising are accurate. Even compliance with federal guidelines may not shield companies from liability if consumers allege that those guidelines don't ensure their safety. So that's Beth Bowen versus Energizer Holdings. It emphasizes the importance of consumer rights, truthful advertising, and the role of courts in addressing consumer protection claims. The case illustrates how factual disputes related to standing and product safety can impact the outcome of a lawsuit even at a very early stage. Now, I suspect that when this case is sent back to the district court, there'll be a lot more discovery, there'll be a lot more depositions, and the next thing that the defendants are going to try in this case is they're going to say, this guy from Yale, the dermatologist from Yale who said that there's no safe level of benzene, he doesn't meet the standard for Daubert versus Merrill Dow, the case that determines how experts are certified. They're going to say he doesn't meet that standard, that he's not really an expert, and that his opinions are all just a bunch of speculation and bunkum. And, who knows whether that will actually have credence with the judge who decides this case. So that's what I have for you today. I thought it was an interesting case because I think, particularly living in the South and spending a fairly large amount of time outside in the summer, I wear a lot of sunscreen. And, I really don't want big honking tumors, growing out of my nose or something because the benzene that is in a sunscreen product. And I certainly didn't know that benzene was in Banana Boat because we've used Banana Boat and we've used a lot of it. So that concerns me. Now, obviously, that issue has not been settled yet, and it's unfair for me to say, well, I'm not going to use that product anymore. But I think I have the right to judge whether or not I want to expose myself even to a potential carcinogen. When you get to 69 years old, you've made it past a lot of the things that get people earlier, and you don't want to increase your risk by doing something that may not be in your best interest. If you have any questions about this case, drop them in the comments down below. Of course, as always, you can email me at the address above. If you have the opportunity today, go out of your way. Do something nice for somebody. Many times in the morning, particularly on Monday mornings when it's very busy at a medical office, I will go in and help at my daughter's office by answering the telephone and taking messages and that sort of thing. And the other day while I was there, in addition to my wife who works there, we also have a niece who works there. One of the things that I did that day is I said, hey, we're going to Firehouse Subs. Do you want a Firehouse Sub? And she said, well, I've never been there before. I don't even know what they're like. So we described them briefly, and she said, yeah, I'll try it. So we brought her back the sub, and she said, wow, this is the best thing I've been eating Subway, and I could have had this. She really liked the fact that the bread was steamed and it was soft and easy to eat. So at any rate, I did her a kindness. And of course, whenever I buy somebody lunch, I don't ever expect to be paid back. That's kind of defeats the whole purpose of buying somebody lunch, right? But it's the kind of thing that really made her day, and I think it makes most other people's day when you do that. So if you get the chance, do something nice for somebody today. We can make the world better, one person at a time, one act of kindness at a time, just by trying. Thanks for being here. When you're done with that, come on down, come back to the beach tomorrow, catch me down here, and we'll discuss something else. Hey, as I said at the beginning, none of what I said is legal advice, but let me tell you what, the stuff that's going to be right up here, these are the things that YouTube thinks you might be interested in going forward. Have a terrific day.